Okay, welcome to Remedies. It's the first class, first section. Let me explain how the course is designed and what we're going to be doing over the course of the next 15 weeks, and talk a little bit about some key issues dealing with the subject. First, let me tell you that you may not be aware that as of the February 2015 bar exam, the multi-state will also be testing civil procedure. So it'll now be the 7th multi-state subject. So it is important, obviously, to have a good frame of reference for that. And what I did just before coming up is print off from the NCBE site for you their outline of coverage, so you can start to think about the main topics. And they're the ones that we've dealt with before in Civ Pro, the ones that will be dealt with on the 103 questions that you're going to be required to do. And they're a lot of the stuff that we talk about through the course of this semester. I see Remedies as really sort of an extension of Civ Pro, of torts, of contracts, some property issues, because now, whether you're taking it in next year, your very last semester, or you're taking it following your first year's series of courses, what it does is it asks you to start to put contract principles, tort principles, injunctive relief, money damages, whatever it is, all together. Because when a client comes in with a problem, they don't come in with a problem and tell you, well, it's a Civ Pro problem, or it's a con law problem, or it's a property. It usually is a multitude of issues that you need to address. And so up to now, you've been able to address them in isolation. But when I designed the materials that you'll be reading, what I've tried to do is in each section put together information that is relevant to problems more than a given subject matter. So that oftentimes there will be contracts and torts issues within the same thing, or there'll be questions about damages, and not questions sort of in the abstract. The question now becomes in the real world, where the rubber hits the road. How would we prove damages if we were trying that case out in court? And so I think it's a good transition from first to second, but it's also a good transition from third year into the actual practice of law. And so what you need to start to think about is, well, how would we handle these problems in the real world? And that's what I've tried to pull out in the written materials for you, is to start to think about the actual practice of law and how the theory meets the actual practice, and have you work on that. But I also want you to see from the standpoint of the bar exam, because you'll never practice law if you don't understand that this is now the 7th multi-state subject they're going to test. The machine didn't staple it for me, but it's the first 3 pages. So pull off the first 3 pages and pass it around if you would. And that's just going to give you their outline of coverage, which is hopefully all of this is concepts you have some familiarity with, and we'll talk about through the course of the semester as well. But you also should be comfortable with some of these topics, or all of these topics, frankly, from the standpoint of your study in Civ Pro, even if that brings shudders to you, the notion that you're back in Civ Pro. But it is important to solidify that understanding. The other part of it that I think is important is I have a CD. You should have the CD for the class. On that, there's a PowerPoint presentation with 103 questions that go over Civ Pro in some detail. You're all going to have to do it. You need to do it before the mid-semester break. And so I think for those of you that had Professor Martin, as opposed to me, you probably should do it sooner rather than later, simply because oftentimes it gets us all on the same page faster, and there will be times where we'll use a mnemonic, or we'll say SPV, and if you don't have if we're not all closer to the same page, because while Professor Martin and I both teach Civ Pro, and we both teach virtually all the same topics, we come at it with a different orientation. And so I think it's important to do those sooner rather than later as a review of Civ Pro, because a lot of that is the jumping off point for where we look at here. So you need to do it by the midpoint of the semester. I would recommend, for those that have been away from Civ Pro for a while, you should do it sooner. For those that have Professor Martin, you should do it sooner. And it doesn't hurt for all of you to do it sooner, but some of you have just come out of it and were tested on it, so I would imagine you have a greater familiarity with that information than those that have been away from the subject for a while. We generally will have, we usually have, and you can think about this, I used to offer a midterm examination, but I also would give the students in the class the same option as the online students of completing all the questions that are posted each week for all of the classes up to, I think it's class section 8 or 9, the midpoint of the semester. Most students then chose to do that as opposed to take almost all of the last 2 years. But if you can think about it for the in-class students, the online students, this audio is posted for their benefit, for your benefit too if you want to go back and listen to it. They then have to respond to the questions that are posted each week online, and they submit those by email to me. They are responsive. If you looked at them, they should be responsive to the readings that and the discussions that take place. And so therefore a lot of students, even the in-class students, ultimately, more often than not, decided, I'll do that to take home, and then I don't have to worry about sitting in class for an exam. You don't need to decide that today. We can talk about that again later in the semester. But if there's a midterm exam, it's going to be before the semester break, if you choose to, you'd rather go that route. Beyond that, you're expected to attend class, you're expected to participate in class. I don't think that'll be a problem. What I've tried to do is select readings for you that would generate some level of discussion and interest, and it usually does. And I think it's interesting material. It's different material than you're probably used to from the case book, because again, trying to get closer to the actual practice of law, when we're looking for cases and trying to pull information out of the cases in the actual practice of law, no one's already edited it for us. And so the cases that you've got are unedited, and your obligation as the lawyer is to edit them and try and figure out what I should be extracting from it and what's important. And oftentimes you have both the full majority and the dissent, if there is one, so that we can debate the law and the logic that's involved in those cases. So there's not as many cases in each section because, again, you've got full cases, and I'd rather focus on substance than just simply giving you so much information that you're not necessarily going to read or retain it all. What I've tried to do is selectively give you information that we can work on and that you should be thoroughly conversant with by the time you come to class. We'll have a final examination. Both the in-class students and the online students have a final examination at the end of the semester. It's a 3-hour examination. And beyond that, I don't think there's any other requirements for you guys. And the only other additional requirement for those people taking it online is they must submit their responses timely to me when the questions are posted each week. And beyond that, I don't have anything else to add about the sort of the course requirements and the like. Do you have questions? Go ahead.
Professor, I've got a question with regards to the CDs themselves, and I've noticed maybe some of the other students with the Macs can answer it, but I don't think it's compatible.
Macs we got trouble with. My understanding is it's not Mac compatible, is it?
I'm trying. Great.
We have to talk to Dan. I think that could be an additional problem. How many of you have Macs? Wow. Okay, this. We'll talk to Dan and Mick and try and figure that out, because imagine there's as many multiple people online with it as well. I'm sure you can extract. They can extract the paper contents. I don't know about the PowerPoint. Does anyone know? Any of you know whether that's somehow readily convertible to a Mac? No, you push the button and turn it on. Yeah, you must know.
It's just a PowerPoint file, sure.
The PowerPoint can be converted to the Mac?
There's a Microsoft Office version of PowerPoint for the Mac.
Okay. And what about the paper materials? I think, what is that in now? Do you know? Anyone know? Is it relatively easily convertible to a Mac?
It should be. I mean, if it's Microsoft Office, then you can get the trial version that lasts for like 180 days of Office and open a PowerPoint on that. If it's just a PowerPoint file.
Okay.
PDF should be equivalent on any systems.
PDF would be okay. So Matt says it shouldn't be a big issue, right?
I think so.
We'll trust Matt. But we'll check with the in-house as well, and Matt, maybe one of them may touch base with you just to make sure that everyone's on the same page, because that's, I know in the past it hadn't been, but at this point, hopefully, we can overcome those technical difficulties. Okay, so you haven't been able to, I mean, I don't think it's going to open on its own in there.
No, I put it in there, I try to fidget with it, but I mean, my knowledge is very limited as far as what I can or can't do as far as converting any files, PDF, or any other type of media files. I do have the Microsoft Office just for papers and stuff like that when I submit it to professors and stuff, but I don't see how that's going to apply to obtain
open the
extracting
PowerPoint
information that'll be compatible to Mac. If you have any suggestions,
I can take a look after class with it, sure.
Okay, that sounds great.
Okay, we'll pick, and hopefully we'll get it. No matter, well, not hopefully, we will get a solution one way or the other for you. Anything else? I have another handout. But you've all seen the syllabus is outside my office. The syllabus is also posted online. And again, it's just broken down into the sections. By the way, I'm going to be in Albany this Thursday, so there is no class this Thursday. That might be an opportunity to do the 103 questions if you wanted to get a jump start on it. What were you saying? What were you going to say, Sandra?
The CDs are not working.
What?
My CDs are not working. How can I do that?
Good point. It's also loaded downstairs in the computer lab, but you're right.
You can copy that.
Huh?
So you can copy it.
Well,
Get a
yeah.
PC.
Huh?
Get a PC.
We'll solve this problem. Right. It does make a more immediate problem for this week. Any other questions? Any questions that we can solve? Thank you. Okay, so as I said, and I'm going to get you out of here early tonight if this is your last class. And you're heading to the South Shore, maybe you'll be able to beat some of the snow down there. So we're not going to go that long. But as I said to you, when clients come into the office, they come in with a problem. They don't come in with CIPRO or torts or contracts. And so when you start to think about it, what you need to start to focus on is a solution to that problem. And we still focus in law school, and the course does, and so does CIPRO, obviously, on the litigated result, how we are going to push this case through the civil process so that hopefully opportunities will present themselves where we'll be able to resolve the conflict. And as much as I would encourage you to try to be pilgrims, to be early settlers, the problem is you've got to get the other side to come to the table so that they will understand that they risk more by pursuing and continuing the litigation than they do by sitting down and being reasonable. But that's not always as easily said, done as it is said, is that geez, would like to compromise. So oftentimes still we end up with this litigation process that is expensive, it's time consuming. There are obviously many rules that dictate how that process works. And you need to be fully familiar with it. I oftentimes use the illustration, whether it's CIPRO or evidence or whatever rule-based law you're looking at, is that you wouldn't be playing cards if you didn't understand the rules. And if you don't know the rules of evidence, and if you don't know the rules of civil procedure, then you shouldn't be involved in litigation, because the person who knows the rules better is more likely going to win than the person who's just sort of fooling around thinking they know what they're doing. So what I've given you is just a simple flow chart to start to think about conceptually how a case begins and how it would flow through that process, and the things that you should be thinking about there in that process. And so if you just look at the left side of the chart, when we file suit, we're looking at having to establish subject matter jurisdiction, personal jurisdiction, and venue. And again, the CDs go into greater length with it. Obviously, the CIVPRO course goes into greater length with it. But subject matter jurisdiction is the power over the court over the controversy. They have to obtain it from somewhere. Usually it's a statute, or it could be the Constitution. In federal court, the three most common ways of going to federal court are on a constitutional violation, or on a federal question, or diversity jurisdiction. And diversity jurisdiction requires that no plaintiff be from the same state as any defendant, and the claim be reasonably likely to exceed $75,000. But we have specialized courts in Massachusetts as well that have subject matter jurisdiction, power to entertain various controversies. Probate and family court, here's probate and family matters. A land court, here's land disputes. Superior court is our court that has the broadest jurisdiction in Massachusetts. And for our purposes, because remedies historically has been called equitable remedies at a lot of law schools. But we're not looking at simply equitable remedies. You understand what equitable remedies are: injunctions, declaratory relief, specific performance, and the like. But our focus is going to be on remedying the client's problem. And that's oftentimes not limited to what's of an equitable nature, an injunction or declaratory judgment. Oftentimes we might be pursuing both equitable relief and money relief at the same time. And not every court in Massachusetts can issue injunctive relief. The Superior Court can. It has the broadest possible powers. But a district court in Massachusetts does not have that power, so that becomes an issue as to what type of relief you might be seeking, as to what courts have the appropriate subject matter jurisdiction to entertain it. As I've said to you before, if a court doesn't have subject matter jurisdiction, they don't have the power to hear the case, any judgment they render is void and it can be challenged by anyone at any time. It's that important. So you've got to always make sure you have established that you are either filing suit in the right court, or that the person that's pursuing litigation against your client is in the right court. Personal jurisdiction is based on something the defendant has done there, right? Contacts, ties, and relations. You remember the cases. International Shoe, Worldwide Volkswagen, those types of cases where, because of the defendant's activities within a given jurisdiction, they are amenable to suit there and then service a process. Personal jurisdiction and venue can be waived. Those are defenses that if you don't raise in your first move, you've lost them. And now it becomes very important as we start to think about practices, well, how realistically do I waive them? Do I raise them? You waive them simply by not asserting them. You raise them generally by way of a Rule 12 motion. And we're going to look specifically at various times through the course of the semester with a little more detail to what those rules say and under what circumstances those rules come into operation. So personal jurisdiction can be contested and is generally contested by way of a motion to dismiss, and in the event it is not contested, it is waived. Same thing for venue. Now, venue is more mechanical of the three, but venue, really, the test generally is where the defendant is or where a substantial part of the events giving rise to the cause of action occur. You need to find a court where you have all three things. And sometimes you will have them in both federal and state courts, so you'll have questions about which ones you should go to. Oftentimes you will have multiple jurisdictions where you can satisfy questions of subject matter jurisdiction, personal, and venue. And now you have to decide, again, based on some considerations of practice and the like, what makes more sense. I always would rather play a home game than an away, simply because I'm comfortable here. It's cost me less. It's more convenient. I know the people in the territory. But maybe there will be times where it makes more sense to go out of state to file suit. And then there are additional issues with respect to that, because you may not be licensed to practice law there. Maybe you need local counsel. All of these become real-world considerations depending on what our choices are with respect to SPV, subject matter jurisdiction, personal venue. At some point, you're going to find a place where you can file suit. Then you're going to feel comfortable that that's the right choice, both from the standpoint of the law and from the standpoint of maximizing your client's return with respect to that case. At that point, you file your complaint. If you want a jury trial, you must demand it. As it says here, clear and concise statements of fact, not conclusions of law. We have notice pleading in both Massachusetts under the federal rules. Simply put the other side on notice as to what you're looking for, and then the process will go forward from there. If you want to make sure your case is relatively bulletproof, then you better make sure all the proper parties are joined. You can, under certain circumstances, bring a class action. We'll talk about that later in the semester. As you can see, if you looked at the multi-state outline that they've given you, they've said class actions are going to be tested, which isn't a surprise. So we need to think about what the test for class actions are and under what circumstances, and they can relatively be easily removed to federal court, but we'll talk about that. There's certain special types of actions, like interpleader actions and the like. We'll look at that during the course of the semester. And if you're looking for injunctive relief, and we spend some time on both injunctive relief and the different procedural elements of injunctive relief, because again, remedies has historically placed a significant emphasis on equitable remedies. But the fact is that that is only one remedy. Most times suit is brought for money damages, suit is brought at times for both injunctive relief and money damages, but we'll take a look, and we're going to, through the course of the semester, take a look at both. Once the complaint is filed in the appropriate court, you then have to serve the summons pursuant to Rule 4, and once the defendant is served, then at that point, the process takes hold. If there's no answer, if you look at the left side of our chart, then there's going to be a default judgment, meaning the defendant doesn't contest the suit. If the defendant chooses to contest the suit, they have two basic responses they can make. Either they can file a motion to dismiss, and there are various reasons for motions to dismiss, as we'll talk about through the course of the semester, or they can file an answer. Off to the right side of this chart here, it talks about affirmative defenses under 8C. That would be part of your answer. Any affirmative defense not raised is waived. If you have objections with respect to the capacity of the plaintiff to file suit, you need to raise that. Rule 11 we haven't talked about yet, but I assume you talked a lot about it in Civ Pro. It requires you, as the person signing the pleading, to have a good faith basis to go forward, and if not, the sanctions will apply to you. We'll take a look at Rule 11, and we'll take a look at, in a little more detail, at your ethical obligations generally as a lawyer and to the profession, and we'll spend some time thinking about balancing your need to make money, right, to pay your bills, to pay those student loans back, and the notion that as an officer of the court, you can't just let every client who thinks they have a wrong attach your name to the complaint if it's not sufficiently meritorious. Frankly, it's bad business as well as bad practice to not do a thorough investigation at the outset, because if you're bringing a claim that's not factually or legally meritorious, or if you're defending a claim that there's really no basis to defend on, then at some point you've cost the client tons of money with likely an unsatisfactory result, and that likely means a complaint of some sort to the regulatory authorities. That's not good for you, that's not good for business. You know, the fact is, if you've got some of these cases on a contingent basis, meaning you are only going to recover if you recover, and you're filing bad claims that have a snowball's chance in hell of winning, then you're squandering your own resources and ours as well. And so, again, Rule 11 requires you, when you're signing the pleading, to have made that good faith investigation. Good practice, good business sense says that that should be done anyway, because your client might absolutely be correct that they were wronged, seriously wronged, and there's a violation of law. But if there is no support for it, if there are no other witnesses, there are no other documents, and there's nothing to support that claim other than their word, and the defendant has the proverbial station wagon full of nuns as witnesses and ample other documentary support, you have an obligation to your client before filing that suit, before taking $10,000, $20,000, $30,000, $50,000 from that client to say, to have them come to Jesus' meeting where they understand, I'm not sure this claim will ever be successful, and I'm not sure I can advance it, even though both the client and you have some belief that it has some merit. Because winning in a lot of these cases is really, well, not a lot. Winning is the only thing that matters to the client. They can tell you a lot of other things matters. And sometimes it's vindictiveness and it's other things that don't belong in the mix. But the fact is, if they're spending money or their time and they aren't likely, and not just not likely to win, because that's the other part we'll talk about through the course of the semester. I've advanced cases that I don't think are likely to win. That's not the standard, and won some and lost like I should have on others, right? That's not the standard for Rule 11. Rule 11 says it's not sufficiently meritorious, that there is no factual or legal support, or that the claim or defenses are interposed for harassment or delay. And there are times where those things are part of the client's expected return that doesn't have a place for it. And that's where you've got to separate out some of the animosity and the anger in litigation from the facts and from what your obligation as the officer of the court is. And that's not always easy to do. And frankly, at times it's relatively easy to have a client who is willing to pay for to vent that anger and to cause some havoc. But at the end of the day, you have an obligation to the court as well as the client. And Rule 11, the bottom line is that the court has the power to sanction you monetarily. And it's not picked up by your your malpractice insurance carrier. It comes out of your pocket. And so you've got to be careful with it. Well, we're going to spend some time on your ethical obligations and how you're going to really sort of balance some of those issues. Because the other part of that, and we'll talk about this as well, is the best defense is a good offense. And if you're involved in significant civil litigation, even some smaller pieces, oftentimes the first thing they do is attack the advocate. You know, this claim is this, it's that, what have you done? And you want to make sure that you've dotted your I's and crossed your T's so that when that charge comes, and especially, frankly, it comes with new advocates. If I think I can make your knees buckle and I can scare you and I can win that way, there are an awful lot of advocates that will do that. May not be right, probably isn't right if that's their intent, but there's a lot of bullies in our business. Again, it's another reason why you want to make sure that you're confident about what your investigation has shown, so that when that scorched earth defense comes, that you're able to withstand that, and then able to withstand the dispositive motions that are likely to be filed, right, under Rule 12, motions to dismiss as well as summary judgment. So again, we'll spend some time thinking about that. And then counterclaims and cross-claims, again, the best defense is a good offense. There are various times where as part of your answer you can file a counterclaim. We'll talk about the two different types. Also cross-claims, a lot of pieces of litigation, and again, the outline of coverage from the NCBE talks about, they'll be looking at that as well, is that as we teach, as I talk about litigation, we often put one plaintiff against one defendant. That's just not the way a lot of cases are. You know, there's multiple defendants. They then end up suing each other. Some of them will file counterclaims against the plaintiff. You go big or go home. Some of this litigation turns into an unwieldy mess. And you've got to be able to sort some of it out and understand how that works. And frankly, if I have a counterclaim against the plaintiff, I'm going to assert it. And if I have a cross-claim against other parties that I can grab some indemnification from, I'm going to do that as well. That's your job. And so you need to understand how that works as well. Once the answer's filed, we get to do some discovery. Federal Rules of Evidence, Federal Rules of Civil Procedure say you've got to make some voluntary disclosures of information first before discovery can begin. Massachusetts doesn't do that. We'll talk about discovery. We'll talk about electronic discovery. Obviously, these days, you need to spend some time thinking about electronic discovery, because we can call it e-discovery, but that is where the documents are. It's in the text messages. It's in the emails. The proof these days, that's where we're going to be found. If you think about the stuff that they've got with the Hernandez case already. It's videotapes, it's text messages, it's information that 15 years ago we wouldn't have thought would be so readily available, and now it seems like many criminal cases turn on the stuff that a few years ago would have been almost impossible to find. Look how they found the marathon bomber with all the video cameras that lined Boylston Street and the like. And the same thing applies with respect to text messages, other electronic or soft copy information. That's discovery, and so we need to think about discovery in that context. The scope of discovery, anything that's relevant or that which will lead to relevant evidence, and then looking at the methods of discovery in the middle here, and I'm not going to go over each one, but you can see there are various means of discovery. And in civil litigation, again, this becomes the bulk of what we do, right? The complaint gets filed, they're going to be served, they're going to have 20 days to answer, the answer will be received at some point, and then we're off to the races in discovery, and that could take a year of our work over to try and get all the information we want, to try and continue to push when the other side doesn't respond timely or just tries to avoid providing the information. And so we've got to think about the means of discovery, who that works against, and how that specifically will work in some pieces of litigation. So that's what's in the middle of our group here, is the methods of discovery, and we'll talk obviously about that. At some point, summary judgment is on the table. I like to talk and have you think about what I call the 3 testing motions, which occur, major motions which occur during the course of a case. A motion to dismiss, which occurs early, tests the sufficiency of the complaint, both substantively and procedurally, for defects in essence. Motion for summary judgment tests the pleadings taken as a whole to see if there are material facts in dispute, and if not, the moving party is entitled to judgment as a matter of law. I haven't had, I would say major, I was going to say major civil case, but I'd almost say any civil case. I think I've had one in the last 10 years that I can think of, and I don't know why he didn't do it. I think he should have. That he didn't file a summary judgment motion on it. You do it. You know, for the most part, the defendant does it. They don't have the burden of proof. You never know what you're going to be able to knock out. As I see it, it's a testing motion. And depending on the judge, some judges see that standard as more elastic than others. I don't think that's right, but if I were them and I've got the right judge, I would do it. I would almost do it as a matter of course. And so summary judgment becomes a vital weapon in our arsenal, both from the plaintiff standpoint, but more often from the defendant standpoint as well. It's the second of our 3 testing motions. And the last one is motion for judgment as a matter of law under Rule 50. And that tests the evidence introduced at trial. So those are the 3 major testing motions that are likely to occur, and you need to think about that. I thought it was interesting looking at, again, the multi-state bar examination outline of coverage that they, and I think, I'm positive it's a mistake, because they talk about the Federal Rules of Civil Procedure, but then they make reference in Roman numeral 5 to directed verdicts and judgments notwithstanding the verdict, and it hasn't been called that for some time under the federal rules. So while they say Roman numeral 5 motions, B, motions for judgment as a matter of law, that is what it's called now. I don't know why they have the parens there, but those are the motions that test the evidence introduced at trial to see if a reasonable jury on the basis of that evidence could find for the other side. If summary judgment is allowed, then the case is over. If it's denied and discovery is completed, we're going to go to trial. If it occurs after discovery, then we're going to go to trial. At some point, if you don't comply with discovery, I'm looking for sanctions. But then at some point in a civil case, we're looking at trials. And from the standpoint of trial, obviously, plaintiff's got to show both liability and damages. Your civil standard of proof is preponderance of the evidence. Tip the scales in your favor ever so slightly. More likely than not, what the plaintiff's saying is true. Remember, if It's an equitable remedy. You have no right to a jury trial. So if it's only seeking an injunction, it's a judge-made remedy only. If it is a money damage claim, then you have the right to a jury trial, assuming that you've demanded it. If it combines both, a request for injunctive relief and money damages, then the modern practice is that the money damage claim is tried to the jury. The jury will make whatever findings and judgment they have on the money damage claim. Based on those findings and that determination, then the judge will make a determination in his or her discretion with respect to the injunction. However, the facts the jury has found, assuming they found some, are going to be what we call collateral estoppel with respect to the facts. Collateral estoppel, res judicata, two important legal principles about issue and claim preclusion based on the claim having been tried at one point, and if there's been a full, fair, and final judgment, then that's going to hold as a matter of collateral estoppel if it's issues that have been decided, and if the claim has been decided, that's res judicata. You get one bite at the apple. Plead whatever different legal theories you have at that time, but at the end of that day, when that case goes to judgment, you can't then file suit for other things that you could have filed suit for on that. If you don't like the result, you can't just sue again for the same problem. That's res judicata. At trial, a bunch of different things happen. Again, this is just sort of a brief overview. Rule 51, jury instructions. The court instructs the jury on what the law is. You don't like the jury instructions, you got to object. If you don't object, you've waived your rights to take that issue on appeal. Rule 48, federal system, it's a unanimous jury even in a civil case unless we agree otherwise. But in Mass, the rule is 5-6 or better. I do not need, the rules don't require a unanimous jury. All I've got to do is convince 5 out of the 6 or 10 out of the 12 that I have established both liability and damages by a preponderance of the evidence standard. Preponderance of the evidence. More likely than not, what the plaintiff is saying is true. Rule 49, jury into special verdicts. If you don't ask for a more detailed verdict, you're going to get what we call a general verdict. We fine for the plaintiff for $5 million. Doesn't tell us why. Doesn't tell us a lot of things. Jury interrogatories or special verdicts help the jury arrive at their decision more easily. A special verdict might break the matter down into 4 or 5 questions. Do you find the plaintiff suffered any damage on or after such and such a date? The reason we might be using on or after such and such a date is if there are statute of limitations issues potentially. Do you find that the plaintiff suffered damages as a result of the defendant's breach of contract or negligence, whatever you want it to be? Again, those are special verdicts. You're breaking the verdict down so that we can then look and see how they've arrived at it. Jury interrogatories are even more detailed than that. They take them back in the room and they go through them one at a time to try and figure out whether what their verdict should be. I like jury interrogatories because it allows you, as the advocate, to in essence speak to them while they're in the jury room, and to the extent you can make those simple and easy to follow such that they find for you, all the better. And so if you break it down into baby steps, I think it's more likely they're going to get to where you want them to be. So I like a more detailed verdict, and I generally use jury interrogatories. We already talked about judgment as a matter of law under Rule 50. That tests the sufficiency of the evidence introduced at trial, and then ultimately all of this boils down into a judgment. If you're seeking injunctive relief, then again that question would go to the judge, and there are 3 different types of lives we give to the names of the lives we give to requests for injunctive relief. Temporary restraining order is the initial order. It can be issued with or without notice. Preliminary injunction occurs after the defendant has been served, and relatively early on in the case, and then only after there's a final determination in the case, a judgment, can the court issue a permanent injunction. Whether it occurs as a result of a TRO, or prelim, or permanent, the test is always the same. It's a 5-part test for injunctive relief. You've got to show that there's no adequate remedy at law. You've got to show the likelihood of success on the merits. III, you got to show immediate irreparable injury. 4, the court has to balance the harms. Hopefully the harms tip in your favor to granting the injunction, but obviously there are competing harms when one seeks injunctive relief because the other party is going to be enjoined. And then lastly, you've got to look at what, if any, public policy considerations there are. I don't know whether the decision will be issued while we're in class this semester, but one of the more controversial ones that's presently before the Supreme Court on injunctive relief is the abortion cases and the zone around the abortion clinics that the courts have issued injunctive relief with respect to prohibiting the picketers from going within that area. The Supreme Court has heard that case. Whether they will issue that or not at this while we're together, I'm not sure. But obviously, as you think about that 5-part test, there's significant public policy issues on both sides of that equation. The harms obviously have to be assessed, and all of the factors have to be, and they ultimately go into a mix. I think it'll be interesting to see how the court balances the public policy considerations in that case. Public policy has to be weighed. In every case, there isn't significant public policy concerns. No adequate remedy at law simply means money damages won't make the plaintiff whole. Likelihood of success on the merits simply means who's likely to win here. If I'm likely to win, the more likely I am to win, the better the reason I should get my injunctive relief now than having to wait 2 years for this case to get resolved. Immediate irreparable harm or injury. You're asking the court for extraordinary relief, ordering a party to do something or to be prohibited, to restrain from doing something. That's an extraordinary remedy. You must show immediate irreparable harm or injury. And then the balance of harms is oftentimes a strong argument that the defendant advances, and so does the plaintiff. If the plaintiff has to advance immediate or irreparable injury or harm in order to get the injunction, the likelihood is that there will be some harm to the other side occurring as well. Those are the 5 parts of the test. We're also then going to look at the procedural methods and requirements. There has to be a bond posted under Rule 65. The size of the bond, the court will have to establish based on an argument that you will advance. And then under what circumstances the right to appeal that preliminary injunctive relief is a question of, can I appeal it immediately? Do I have to wait till the case is over? That's sort of a brief capsule of the stuff you need to be thinking about as the case proceeds and winds its way through litigation. Look at your outline of coverage, look at the syllabus, look at this, look at the 103 questions, hopefully sooner rather than later once we solve this problem. You don't have a class on Thursday. Our next class then will be Tuesday, so there'll be no audio for the online people for Thursday's class because there is no class on Thursday. Any questions? Yep, see?
Should we stay ahead with the syllabus?
Yeah, I think the next section is on a bunch of readings with respect to attorney's obligations, is it? Settlement, lawyer's peacemaker?
Mediation, yeah.
Yeah, so read the articles, read the stuff that's in that section, and then we'll do that all next Tuesday and Thursday. Okay? Say what? Yep, right here.
Is that the same CD as the Civ Pro?
Yeah, by the way, for those that got it first year for Civ Pro, the written materials are in there, so is the PowerPoint. They are the same. You don't need another.
So that's the 103 questions, the same?
The same 103 questions for PowerPoint.
Oh.
Which CD though?
Huh?
Which CD, last year's or 2 years ago?
I haven't changed it. I wish I was supposed to, but I haven't. So it's the same one.
Yeah, they still owe me a new one.
So if I have that CD, can I go get my money back?
Oh, you bought another one this time? Yes. She's going to give you a hassle. Will you tell her I told her?
Yeah, she already gave me hassle for one class, so I can get my reimbursement back.
Yeah.
So just with my schedule, I was signed up for a trip with Bonnie, so I should just be able to switch it over.
Yeah, exactly.
And then my only question was about I did the 4 to 550. Is that gonna be a problem?
I know, but you can't like, you know, like I use a lot. I like to. Yeah, I like to use a lot, but why is he? But I don't like. You don't like the. I'll use it a lot like that. For some reason, like control Y and Z, you know, it just takes away the last thing. I don't
think so. I mean, I'd rather have you there, but
maybe it
what else would you take if not that?
I don't know. I don't think so. You know, I just don't want to work.
I can look and see if
These are the,
Yeah, right. Yeah.
it's my 7:30 slot. It's not open.
the audio.
Oh, then look and see what's there, because that would be, it would be better to have you than not. And then you could grab a 3 instead of a 2.
Yeah. Okay.
Okay.
Right, figure out something. Somebody.